Hello there, and good morning, and welcome to my podcast today, which concerns the question of whether or not you have received a threatening email from one of the many image rights collecting agencies who are based usually outside of the UK, and their attempts at securing payment for a license seems to be causing some controversy. So I thought that a short podcast, which will support an article on the website, which I posted, will prove to be of some use to you all. So, for the past 20 years or so, Lawdit has been advising clients on various copyright matters. And in particular, various allegations of copyright infringement. The complainant is usually an agent or licensee of the original owner of the works in question, which are more than likely than not photographs. So, for example, Getty or Copytrack or Image Rights will have software which they say establishes that you are using an image that they have been appointed to manage collectively, and as you don't have a license or haven't paid for the rights to use the image, they are threatening you with legal action. These agencies are usually outside of the UK, as I say, in Germany, US, Spain, and they indicate that they were willing to settle provided that I provided that you pay a fee and or some damages by way of compensation. So firstly, you need to identify and ascertain exactly where the image came from. Often we hear web designers who were commissioned to build and create a website have used images, and so the customer, you, the recipient of the threatening letter, is left slightly bemused because you believed that you had engaged the web designer in good faith. Sometimes the owner himself is contacted and grants permission to the infringer, and sometimes there is no license fee and the person has just lifted it from the website. Look, you should always remember in these instances that copyright use and the use of these images is hugely dependent on licensing. It's about permission. What permission have you been granted to use this image, and for what term, i.e. duration, geographical, etc., etc. So often you do have to pay a fee. There are stock image websites out there, but you can't rely on them, as you need to look into detail as to the terms and conditions as to what rights the author owner is demanding for you to use this image. So from a practical perspective, when you are going to work out the payments for the image in question, we look at pre-action and litigation. So pre-action is where you will receive a letter and the rights agency image holder will be seeking some form of payment. First thing you need to do is to remove the image in question. There's no point keeping it up there, irrespective that you have a good defense or not. Take it down. Secondly, they're often undertaking some form of binding contract attached to the original letter. Don't sign anything. Thirdly, look at your email history, talk to staff, talk to web designers, and ascertain whether or not you do feel that there is a license fee to pay. If there is a license fee to pay, and then you have to pay something because someone's gone to the trouble of creating the work, damages and payments are quite interesting. In strict terms, the English law puts you back into the position as if the wrong hadn't occurred. So in simple terms, a photographer charges £10 for an image if you just went to him in the normal course of dealings. If you are accused of copyright infringement of that same image, then you shouldn't have to pay £250, you should only have to pay £10. So that's often a way of taking the wind out of from the sails of these agencies by saying, fine, I'm really sorry about that, I will pay you for the original license. And it ought to go away. Now, it ought to go away because if that doesn't satisfy the rights holder or the agents of the rights holder, then they'll need to consider legal action. The problem with legal action is, as the damages involved are considerably less than £10,000, in this case, if they decided to issue a claim, would be allocated to the small claims track at the Intellectual Property Enterprise Court, St Thomas More Building in London, in the High Court. Now, don't panic. There isn't an immediate liability to costs. Because we're in the small claims court, there are no costs applicable. So these companies that are overseas threaten with external lawyers, but they would have to pay for these external lawyers themselves and not recover that in the small claims. In addition, they need to be put to proof as to various aspects of copyright law, and put to proof by producing evidence that they have the rights to actually bring a claim. In addition, an exclusive licensee needs to be joined to any claim. So the article sets out the sections of the Copyright Designs and Patents Act which you need to quote when it comes to any kickback. More than happy to discuss this with you via email or give us a ring. But I hope this was useful. Certainly don't panic, and it can be managed and dealt with quite simply. Okay, cheerio.